Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Before he was shot and killed by police, Rodger Kotanko was a very well-liked and well-respected gunsmith. He specialized in high-end custom guns and was really popular with the competitive shooting market. And ultimately, he was shot in the course of a raid. They were looking to execute a search warrant based on suspicions of weapons trafficking. The allegations were that Mr. Kotanko was selling guns on the side and not through proper processes. But this has always seemed a little strange to a lot of us. Personally, I look at this and the amount he could get for selling these guns to competitive shooters was a lot higher than he'd be able to get selling them on the streets. It didn't make a whole lot of sense to me, and quite frankly, seemed more like he might have had some paperwork problems rather than anything nefarious. But there are other questions that have been sort of lingering over this one. One of those questions is why a police force that wasn't the local police force was executing this warrant. They actually had to drive for like an hour to get there, and they didn't even tell the local police that they were going to be in town when they were doing this, which seems strange. So a lot of us have had questions about this and whether the shooting was justified, whether it was necessary, whether this was executed in a proper fashion. In particular, Mr. Kotanko was a gunsmith, and they waited until he was in his workshop in order to go and confront him, which seems like the dumbest possible thing to do. That actually seems like trying to provoke some sort of confrontation. Anyway, the Special Investigation Unit investigated themselves, and they ultimately cleared themselves, which is really what you expect. Now, Mr. Kotanko's family is suing the police, and hopefully that'll get us some answers. But we now also have a new lawsuit. There's another lawsuit, and that's from the witness who was in the warehouse or in the workshop when Mr. Kotanko got shot. So this comes via Jennifer Beeman. She reported on this for the London Free Press. She did excellent work, so check that out. I'm going to link it below. But we're going to go over the statement of claim together because let's have a look at what's going on. So the first thing we'll notice here is that it's CW, SW, HW, and RW versus the police. Now, it's really unusual that this is filed as initials. And I had speculated previously that the other person in the workshop might be somehow connected to the police investigation. And this seems to suggest that maybe that's the case because these are all adults and it's unusual for adults to be filing anything under initials as opposed to their full name. Normally when you sue somebody, your name is out there. This seems strange. So I actually took the step of confirming that there was no publication ban. So there's no publication ban as far as I'm aware of, at least not as of when I called earlier today. But I have some questions. Now, they're suing 5 unknown officers. And the reason why these are unknown John Doe officers is that they never actually released the names of these officers. But maybe that'll get revealed through this lawsuit. They're also suing Inspector Norman Proctor, Police Chief James Raymer, Toronto Police Services Board, as well as the estate of Rodger Kotanko. So they're suing Mr. Kotanko after he's passed. All right, we're going to skip over this first bit. This is just a cover sheet that's required to be included on everything, and we'll go to the claim. So what is it they want? General damages, 1 million. Special damages, $500,000. Punitive, aggravated, and exemplary damages, $500,000. Now, when you've got these nice round numbers like this, they're just ballparking it. They're picking a number that's more than what they expect it's going to be because the court's never going to give you more than you ask for. So you ask for more than you think you're going to get. Damages for the loss of the plaintiff, CW's guaranteed rights and freedoms in accordance with Section 7 and 24(1) of the Canadian Charter of Rights and Freedoms. Now, I'll note that the courts have agreed that this is something you can sue over, that you can get damages for violation of your rights. Typically, those are small numbers, like less than 5,000. Also, Americans will probably be looking at this going, wait a minute, these are small numbers here, and Canada, you get less money in lawsuits typically than in the States. So plaintiffs SW, HW, and RW are each claiming damages under the Family Law Act, which says that family members of somebody who is harmed can also make claims for losing basically some of the things that they'd expect as part of the familial relationship. So they're asking for $200,000 each. They're also claiming interest, both pre-judgment and post-judgment. And pre-judgment interest means basically from the time of the incident up until the court case gets resolved, interest is accruable during that time. Post-judgment interest is after the court case says you get X amount of money, right up until it's paid, interest accrues during that time. So that's default, that's expected. They're also seeking costs. You always ask for that, as well as any other relief that the court may they say seem just. It should be deemed just, but you always ask for this as well. You basically, court, if you're going to give me anything else, I want that too. You always ask for this because if you forget, maybe the court doesn't give you anything. So, all right, so what is this lawsuit about? So, plaintiff is an individual who resides in the province of Ontario. The plaintiffs SW, HW, and RW are his adult children and live in the province of Ontario. So they're making that claim pursuant to the Family Law Act, as I mentioned. Defendant officers John Doe 1, 2, 3, 4, and 5, whose names are currently unknown, are police officers with the Toronto Police Service Integrated Gun and Gang Task Force. At all material times, they were involved in a police raid of premises of Rodger Kotanko in Simcoe, Ontario, and the shooting death of the same. Now, the document I have does not let me redact it, so, but this is public record. The defendant, Inspector Norman Proctor, is the officer in charge of the Integrated Gun and Gang Task Force with the Toronto Police Service, and at all material times was involved in the execution and planning of the raid, which resulted in the death of Kotanko. So you might be saying, why does this guy get to sue? Why is he suing over somebody else's death? Well, we'll get to that. We're going to skip over the parties because you already know the rest of them, like the police force and the estate of Mr. Kotanko. But background. On or about November 3rd, 2021, the defendant officers arrived from Toronto, Ontario to the Simcoe, Ontario home of Mr. Kotanko. They were traveling in 3 unmarked police cars and intended to investigate whether Kotanko was involved in firearms trafficking. Although the defendant officers had traveled outside their Toronto jurisdiction, they did not advise the Ontario Provincial Police or any other police service with jurisdiction in the Simcoe, Ontario area about their arrival or intended activity. The plaintiff, CW, had recently purchased a used handgun, a Norinco 1911 A1 compact 45 caliber pistol. So basically a Chinese 1911 knockoff. Other persons recommended that he take the gun to Kotanko to inspect and make whatever repairs might be required to the gun, and gave him Kotanko's phone number. CW had not previously known and had never previously met Kotanko. In late October, CW first brought the gun to Kotanko, who made repairs related to the gun jamming. Subsequently, CW found that the grip safety was not properly functioning. The grip safety on the gun is a mechanism that should disable the gun unless someone is holding it. So that is to prevent it from going off if it's dropped or if it's, jostled in a bag or something like that. It's intended to ensure that it's only fired when somebody is trying to fire it. So that's what the grip safety is. CW called Kotanko on or about November 2nd, 2021, and arranged to meet him the next day for an inspection and further repair his recently required handgun. There's a word missing there. Further repair of? So CW arrived at Kotanko's premises at the agreed upon time in the morning of November 3rd, 2021. CW waited in the driveway of Kotanko's premises for more than an hour. He then called Kotanko, who advised him that Kotanko was out shopping with his wife and would be home shortly. CW waited for their arrival. CW pulled his vehicle out onto the road in front of the location. When Kotanko returned, he pulled his vehicle back into the driveway. At all times, CW was clearly visible, seated in the driver's seat of his vehicle, parked at or near the location. No police officer approached CW while he was on the driveway. CW was given no advice that a police raid was about to take place. CW was not afforded any opportunity to leave in advance of the planned police raid. So he says he didn't know that a raid was going to happen. Now, I'm wondering, will that turn out to be the case? Why is it listed as CW? This is very odd. But it would also be unusual for a police officer to, if they're planning a raid, they don't typically go and stop people nearby and are like, hey, you gotta go. Because as far as they know, they could think that this guy's in on it. And, hey, you should leave here. We're about to raid. The next thing he might be doing is phoning Kotanko and going, do you know that there's a police raid about to happen at your house? Which might have actually saved his life. Just a thought. So, sometime later, Kotanko and his wife, now known to the plaintiffs as Zukin Mai, I might be mispronouncing that, arrived home from grocery shopping. It had been CW's intention simply to leave the gun for inspection and repair and to return sometime in the future to retrieve it. Kotanko advised CW that the repair would take only a short time and that he should stay and wait for the work to be done. CW handed the pistol inside a gun case to Kotanko. The two went to an outer building which served as Kotanko's workshop. CW watched Kotanko as he performed the repair work and began to put the pistol back together. The door to the shop was left open. Now, I wonder, was this the first thing he did, that he went to the workshop and left his wife to bring in the groceries? Or did Kotanko bring in all the groceries? Was there time like that? Because the police are sitting there waiting for this raid. And it seems to me that if I was the police running this raid, as soon as Kotanko pulled up, I would have taken him into custody, or at least taken control of the situation, so that he doesn't have time to get to the workshop and get to where his firearms are. You just immediately take control of that, and you're like, great. This is what I've usually seen when they have somebody who they're waiting to return home while they're planning on executing a warrant, is usually they stop them in the driveway. Why did they not stop Kotanko in his driveway when this is what I've seen in every other raid like this that I've seen? This is very strange to me that they let him go into his workshop, because they would have known what his workshop is, right? They've already done surveillance and so forth on this. They know what this is about. So they note the door to the shop was left open. Kotanko was still reassembling the pistol after having taken it apart to repair, when the defendant officers suddenly, without warning, burst through the doorway and quickly entered the workshop. At that point, the pistol's magazine had been previously removed by Kotanko and had not been reinserted. Now, this also seems like a dangerous way of executing this warrant, right? This seems like something that is bound to provoke some difficulties. The defendant officers entered the workshop with their guns drawn. As they entered the workshop, the defendant officers shouted commands to put your hands up. CW raised his hands immediately. Kotanko, who was holding CW's inoperative pistol at this time, did not raise his hands despite further repeated demands to do so. Now, I'm just going to stop here, because this is a place where there's actually a substantial difference in the allegations between that and what we see in the police report, the investigation. So the police investigation report actually has something very different here. So they say, with their guns drawn, the subject officer and witness officer quickly, so the subject officer here is the person who fired the shots, and witness officer is, these are just the other cops there. So they noted there, they say, the sound was coming from the approach of the FEU officers. The SO followed closely by witness officer number 4. The officers called out, police, search warrant, and put your hands up, as they neared and entered the workshop's pedestrian door. The civilian witness says without warning. So without them, that they entered first and then they started shouting, as opposed to as they neared. CW surmised that it was the police and raised his hands. With their guns drawn, the subject officer and witness officer number 4 quickly turned their attention to the complainant, i.e. Mr. Kotanko, seated by a workbench to the left of the pedestrian door. The complainant did not raise his hands at the officer's repeated direction. Within seconds of their entry, he reached with his right hand towards the workbench, retrieved CW's firearm, and turned with it in the officer's direction as they yelled at him to drop the gun. They say the subject officer fired his gun, a Glock 40 caliber semi-automatic, 4 times in rapid succession, striking the complainant and knocking him off his chair onto his back. Time was about 12:15 p.m. Okay, so what is the key difference on that? What is the sort of the big distinction? Well, the big distinction I see here is that he says that CW was already holding the gun and that there was no sort of warning call until they entered. So that I think is a big issue, but especially the aspect of him reaching for the gun versus him already having the gun in his hand is, to me, a pretty critical detail. Because if you surprise somebody who's got something in their hand, they may not drop it. So the defendant officer, John Doe number 1, fired his semi-automatic gun 4 times in rapid succession, striking Kotanko and knocking him off his chair onto his back, mortally wounding him. The shooting took place inside close quarters, in very close proximity to CW, profoundly shocking him to witness a man abruptly and violently be killed before his eyes. CW saw each bullet penetrate Kotanko's body, watched him get blown off the chair and lie on the floor with holes in his clothing. Now, I'm just going to note, he probably didn't get blown off the chair so much as just shot and then fall, right? Bullets don't actually tend to knock people back in that fashion. That's more of a Hollywood thing. But if you are unconscious, then you fall and you're going to fall off a chair. At the same time, others of the defendant officers pointed their guns at CW. The defendant officer, John Doe number 1, having just shot Kotanko, then trained his gun on CW and barked the order, "Don't you move a fucking muscle. If you do, you're dead." The defendant officers ordered CW to exit the shop with his hands above his head. Once outside, CW was manually pulled and forced, prostate face down. Now, I'm pretty sure that was supposed to be prostrate. Prostrate and prostate are 2 very different words. And I hope his prostate doesn't have a face. But this is one of those words that if you're going to include it in a court filing, you definitely go back and you proofread that word specifically. Prostrate was the word you meant, not prostate. Onto the ground and then ordered to put his hands behind his back. The defendant officers then handcuffed him to the rear. He was next ordered to move to the front porch of the house and to sit there while still required to remain handcuffed. CW was visibly, the punctuation on that is really weird. CW was visibly shaking uncontrollably from nervous shock throughout the entire process. The officer's aggression towards CW in the immediate aftermath of witnessing Kotanko being shot to death further exacerbated the shock and alarm that CW experienced. So this statement of claim seems to suggest that he wasn't involved, and it's still unusual that he's got, his initials there. They're listing everyone else by name, but CW by initials? That's strange, right? But he never says he was involved. He says he was surprised by all of this, so we'll have to see what shakes out. Zupanmai, and I think that's spelled differently than it was earlier, Kotanko's wife, was placed on the steps beside CW. She was in a state of panic, trembling and crying, and continually asking where her husband was and what had happened to him. The defendant officers demonstrated little compassion and offered no comfort or solace to either of the two. And that's got to be hard, right? Where you're seeing that they're pulling one person out of the workshop and not the other, and you want to know what's happened to your spouse, and they're just not answering that question. Yeah. Paramedics later attended the scene and transported Kotanko to the hospital, where he was later declared dead. So the plaintiffs claim, basically, they're saying that the police service board is responsible for the actions of their employees. And why do they say that? Why does he say he's entitled to money? So they say that the actions of the officers amount to an unnecessary and excessive amount of force on CW while he was compliant with the defendant officer's demands, i.e., they shouldn't have pointed a gun at me. They shouldn't have said bad, scary things to me, and so forth. The force applied by the defendant officers against Kotanko and CW was not justifiable in law and resulted in the plaintiff CW suffering extreme mental distress and emotional harm. The defendants knew, or ought to have known, that the force they applied during executing the raid would cause an increase in the likelihood of serious injuries to CW. So basically, you use too much force, and that you should have known that this could have harmed me in the way of specifically psychological injuries. Negligent discharge of their duties. They say the state of the force with which the defendants executed the warrants was excessive and unreasonable and resulted in significant mental injury to CW and the death of Kotanko. They also say that the defendants acted with reckless indifference as to whether their actions would cause injury to the plaintiff. The manner in which the warrant and raid were executed was a gross and negligent misuse of power. The conduct of the aforementioned defendants constitutes misfeasance in public office. Now, my biggest, thing, let's assume that he turns around and he's got a gun in his hand. It might be reasonable to take that shot, but it was never reasonable for them to let him go into the workshop. That just seems crazy to me. And if you didn't act and he ends up in the workshop, like if you're still sitting in your car and it's like, where'd he go? Oh, he's in his workshop. Maybe you're going to wait and catch him as he leaves or something like that. It just seems crazy to execute a warrant on a gunsmith in his workshop if you're not hoping that he's going to die. Like that's the only explanation, or there's two explanations that really come to mind. One is incompetence and the other is malice. And I don't know which it is, but this seems so bad. Breach of charter rights. The manner of execution, the want of care, and the needless aggression exercised by the defendant officers constitute a breach of CW's right to security of the person. The actions of the defendants cause severe and ongoing psychological harm to CW to the extent he requires the care of medical experts. So we're going to see medical experts testify about this one. Now, we don't televise trials in Canada, so we're not going to see it online, but there's going to be details in whatever decision about these medical experts. Sadly, this one's halfway across the country, so I don't know if I'll be able to go and see it. And his enjoyment of life had been continuously diminished. The plaintiff, CW, states that the extreme mental distress and suffering he has experienced was caused by the assault, negligence, and reckless behavior of the defendants, the particulars of which are as follows. So the defendant officers, he's saying they were inadequately trained, failed to properly assess, survey, or plan their raid, failed to follow proper procedure in the execution of the raid, leading to a dangerous situation, i.e., why did you let him get into the workshop? Why did you raid while he's in the workshop? It's crazy. And if this guy is like a third party who was not involved, why would you raid when he's there? It makes no sense. Unless they were hoping that maybe he was involved in, some sort of trafficking or something. I don't know. The defendant officers allowed a customer, the plaintiff CW, to go into Kotanko's workshop when they knew their plan was to enter soon after with their guns drawn. The defendant officers knew that firearms would be present in Kotanko's workshop, as Kotanko was a licensed gunsmith. No kidding. The defendant officers allowed CW to be put into harm's way and potentially interfere with the execution of the raid. I mean, what if CW had been holding his gun? Right? What if Kotanko had said, it's all good, it's all fixed, here's your gun, and put it into CW's hand, and then the police burst in and he's sitting there like, in the middle of a police raid, in exactly the situation you don't want to be in when the police are raiding, which is you've got a gun in your hand. That would be absolutely the worst scenario. He could have easily been shot in that circumstance. It's just crazy. So the defendant officer, John Doe number 1, discharged his firearm and killed Kotanko when there was no need to do so. That, I suspect, just because of the amount that the courts tend to give leeway to the police, I don't think they're going to make that out. Although I don't think Kotanko was actually a danger. That said, there's, they're going to say, listen, we were doing a raid. We shouted at this guy to put his guns down. He had a gun in his hand. I don't think that they're going to make that out. So, defendant officers acted in a manner which substantially increased the likelihood that Kotanko and / or CW would be injured or killed. All right, so now we're going to look at why he's suing the estate. And you're going to say, this contradicts everything they just said. And you're probably right about that. Now, the reason why they do this is because there's going to be multiple people pointing their fingers at each other. And so what they, as plaintiffs, don't want is they don't want a finding that says, listen, it was all Kotanko's fault and therefore the police are off the hook and you're just SOL. They want it that if the court ultimately finds that it was Kotanko's fault, that they get money from Kotanko's estate. Whereas if the court finds that it's the police's fault, then they get money from the police. And if the court finds that it's both of their fault, then they still get money. So that's really why they're doing this. This is pleading in the alternative, where you can say, and sometimes your alternatives can be directly contradictory each other. So they say Kotanko was involved in illicit or illegal activity that attracted the attention of law enforcement. Again, all of this is claims in a statement of claim. We don't know at this point, but these are the allegations made in the statement of claim. Kotanko invited CW into an establishment where illegal activity was or had been carried out, thereby creating a danger that armed police or others may attend at the same time as CW. Kotanko failed properly to comply with the demands of police when instructed to put his hands up or otherwise surrender, thereby creating a further dangerous situation for both himself and CW. You see how this is contradictory, right? They're saying the police didn't have to shoot him, but then they're also saying he made the police shoot him. So that's sort of the contradiction here. Kotanko turned towards the defendant officers with a gun in his hands and created a situation calling for the use of force. I mean, you tend to turn towards somebody who's shouting at you to figure out what's going on. Kotanko was also 70 and was a gun owner and a shooter his entire life. And one thing I can tell you about 70-year-old shooters is that they often have hearing damage. And so I don't know what Kotanko's hearing was like. I don't know if he would have necessarily made out what was being shouted at him from behind without turning to get some impression of the context. So another aspect of all of this. So Kotanko caused the situation which resulted in his own death and the extreme psychological injuries to CW. Now you might be saying, how can you sue a guy for causing his own death or sue his estate? The thing is that this happens all the time. Let's say I am driving down the road and somebody is, somebody's being really careless. They're drunk, they're playing in the, in the road, and they end up leaping out in front of my car because they're just, they're behaving irresponsibly. And so I end up hitting them and I suffer injuries, which might be psychological injuries, PTSD, and so forth, damage to my vehicle. Maybe I'm also physically injured, right? Maybe after hitting them, I crash into a car and suffer various physical injuries that cause me other issues. I could sue that person's estate saying, listen, you were behaving irresponsibly, and even though it caused your own death, it also harmed other people. So there's all sorts of possibilities for that. So what are the injuries that CW says that he suffered? Extreme mental distress. CW has and continues to experience PTSD, nightmares, disrupted sleep, deep abdominal pain, and mental anguish, shock, and profound grief. As a result of the defendant's actions, CW has sustained a permanent and serious impairment of an important psychical, mental, or psychological function. As a result of the defendant's actions, CW is and will continue to be unable to participate in vocational, recreational, family, social, and household activities to the same extent he was able to prior to the incident. Basically, he says, I'm really messed up. As a result of the defendant's wrongdoing as particularized above, CW has sustained and will continue to sustain a loss of income. I can't work. As a result of the defendant's actions, CW has suffered and will continue to suffer a loss of competitive advantage in the labor market. I don't know what he does for a living, so I can't comment on that. As a result of the defendant's wrongdoing as particularized above, CW has been required to undergo mental health treatment and diagnostic studies, which are expensive. He will continue to require further treatment, studies, and medical care in future. Full particulars of CW's injuries and damages will be provided prior to trial. As a result of the defendant's wrongdoing, CW has been and will continue to be put to expenses, full particulars of which are not yet fully available, but will be provided prior to trial. As a result of the wrongdoing, unable to perform caregiving, household, and maintenance chores to the extent that they may have been able to do so before, and requires assistance with these tasks, i.e., I want them to pay for a caregiver, somebody like, maybe a cleaner, maybe, maintenance people, like these kinds of things. I'm going to be unable to do those things. I need help with that. And so loss of the other people are claiming for loss of care, guidance, and companionship and other support, which damages they would not have occurred otherwise. And they want this tried in London. So that is our lawsuit here. Now, whenever there's a lawsuit, one of the first questions people have is, are they going to win? And I don't know. We don't know what facts are going to be found by the court. That's way down the road. I think that they've probably got enough here to survive a motion to dismiss, which is when you ask the court to throw it out. Because the motion to dismiss is based purely on the allegations, and they're treated as if they're true, regardless of whether or not they're actually true, because you haven't been able to test that yet. So this should be interesting because this might actually bring more information into the public record, especially if this goes to a trial. Now, more likely it settles in some fashion, and we never actually find out all of this stuff, which is unfortunate because for a lot of us, this has left a lot of questions out there. One thing I'll be waiting a little eagerly to see is the statements of defense, because both the police forces and potentially the individual officers, as well as the Kotanko estate, will be filing statements of defense. And so we'll get to see their responses, and we'll cover that as well. So stay tuned. That's probably going to be in about 20 days, although they may get an extension of that. So as soon as those are available and as soon as I get a copy of them, we'll proceed and talk about those. So thank you for watching. I hope you found this to be interesting or educational. I know a lot of people have had questions about this one. So check that. We'll find out as we can. Want to thank my Patreon supporters at the $50 level, the CCFR, CAIM, Canada's National Firearms Association, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited. And at the $20 level, Larry Kalniak, Here's a Coin Legal Witcher, Cameron Johnson, Andrew Elsich, Vicky, and Dorky Dane. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. Hope this has armed you with knowledge. See you next time.